It will almost be 10 days. What more time can we be asking for? I really want to persuade the court before I give floor to my learned colleague and senior that the third we should maintain the date of the third. Let everybody burn the midnight oil. Let us all put ourselves in the shoe of the persons who are missing. And we can all come back to court and canvass all the issues we want. But the first order in a habeas corpus application is to produce the person, to produce the body, alive or dead. So let the 6 people be produced, and then we can have all the time we want to file lengthy affidavits and to have lengthy submissions. I give floor to my colleague.
May it please my Lord. Habeas corpus is not negotiable. And we have made it very clear. We have heard from an affected Kenyan parent what they are going through as a family. My sister, mother, a learned friend, is the 4th interested party. I want to suggest to you, learned counsel, that all the 55 million Kenyans are interested parties in this matter. Our country is at a crossroads. And may the court take judicial notice of the fact the chief executive of the country has actually gone on record to say, yes, these children will be released provided you, parents, teach them how to behave. These are young, educated Kenyans, aware of their constitutional rights. My learned friend representing the Kenya Human Rights Commission almost nailed it. Your Honor, you will stand in history as the one judge who brought sanity to this country if you stick to your orders. We can all, as learned friends, swear those affidavits from Inspector General of Police, from Director of Public Prosecutions, present them before you, file them even in time. But the reality, Your Honor, is the country is experiencing a most delicate period where you have to help this country determine whether it's a country under the rule of law, under Constitution 2010, or a country ruled by gangsters who are known. Today, I believe if the Inspector General wants those guys here, he will bring them. Some of us have been in government, we know how it works. I beg of you, my Lord, that you do not give way by extending time to 7 or thereabouts. Billy Mwangi's father wants his son now, dead or alive, and the country demands the same. Thank you, my Lord.
Yes, my Lord. Those points have been well canvassed. Yes, my Lord. The last side that I wish to hear from.
My Lord, I only wanted to address you on the import of Article 238, if you may permit. I'll be very brief.
Yes.
But my Lord, what we are dealing with here is a case that touches on the imports of Article 38 on the principles of national security. This matter is so grievous, my Lord, the National Police Service, who are supposed to appear before you today, have negated and disobeyed your orders. In Article 238, my lords, provide national security is a protection against internal and external threats to Kenya's territorial integrity, sovereignty, and its people. Unless this question is answered, my lord, by these individuals appearing before you, my lord, 7 days will be a negation of your orders. Let them first of all address order number 2, even before they seek to extend time to reply. Why is there Article 25? Article 25 is a facilitative article, facilitating other subsequent articles. Most importantly, Article 26. And that is why you're being told, produce the body live or dead. So, my lords, do not be invited to extend this time for whatever purpose. And let's understand, my lords, that Article 238 is paramount in the protection of the rights of an individual and their freedoms and their property and the peace and the stability and prosperity of the nation. So this is not a case about Billy, it's not a case about Mutet, it's a case about all of us. If this court does not bite, tomorrow it's me, Ndegwa, who will be abducted. There will be an application before you seeking to know of where my abouts. My lord, I rest my case.
Councillor Mano, you have the last.
Yes, Your Lordship. I'll leave very well. Your Lordship, I'll be very brief because you've taken substantive submission. Your Lordship will be in opposition by application by the respondents to take one more time.
Just a moment, Councillor. It's not so much an application by the respondent.
Your Lordship, we are seeking to collapse. There are two issues. They want to collapse the substantive application. That was the application that has been made. That has even been submitted. Yes, Your Lordship. What would have been convenient, Your Lordship, was that the respondents would have brought the 2nd to 7th petitioners and duly report to this court that in fact we are in compliance of your orders. The 2nd to 7th petitioners are before you. Hence, let us canvass the substantive issues raised in their petition and application. Secondly, Your Lordship, the petition raises substantive constitutional matters that this court ought to first be satisfied that indeed the petitioners have raised a prima facie case as against the respondent. So again, unless the respondents are submitted before this honorable court that as the petitioners we have proved that our case raises substantive issues, then we could accede to the application for collapse. But more importantly, Your Lordship, let it be not lost that the application raises a cocktail of orders that is not only limited to the issue of habeas corpus. As submitted before you by the parent of the fourth petitioner, Your Lordship, there is an issue of the use of fake registration plates in the conduct and arrest during this abduction. That is an issue that we want to be prima facie established by this court. Not forgetting, Your Lordship, that under Order 7, you had directed the 8th respondent, that is the NTV, to produce records of the said number plates so that it may be known by all and sundry who exactly are these people who arrested or abducted this second 7th petitioner. Finally, Your Lordship, this application and petition was drafted on the 26th of December I'd like to disclose that I was at the comfort of my village, hundreds of kilometers away. But exceptional circumstances, extraordinary times, call for extraordinary measures. It is not about our convenience, it's not about our diaries, Your Lordship. It is about the substantive issues raised in the petition. Habeas corpus, which is the nature of within 24 hours. So we'll be seeking that you stick to our orders unless and until they are complied with. Your Lordship. Yes, Mr. Manuel. My Lord, on behalf of the first petitioner, my name is Kabata, and I want to re-emphasize what has been said by my colleagues, and the petitioner as well as the interested parties. My Lord, we are living in interesting times, and if the court will take the number of days that the second to the seventh applicant petitioners have been missing, it will be possible to say today that that is about 9 days. The uniqueness of today, my Lord, in how we are computing time, is that tomorrow, God willing, if we will all be present here, it will be right to say that they were abducted last year. The application to dispense with the present application by my good friend Mr. Sigogola will lose the meaning of what the court has just cited, that in the interim, the court sits as an inquisitorial body to seek to find